Good morning. The next case to come before the Court of State versus Yuschak. All right, are both sides ready to proceed? And we're ready to hear the argument. You will have 15 minutes each and 5 minutes, up to 5 minutes for rebuttal.
Thank you, Your Honor.
You can get some water next time.
And last time I tried to do that, it spilled everywhere, so I wanted to do that quite carefully today.
Okay, no problem. I understand.
Good morning, Your Honors. My name is Andrea Whitaker, and I'm appearing for the appellant today. First, let me say that I also thank Judge Moore for her wonderful service on the bench. It's an honor to be here today for her last time sitting in Medina. I would like to reserve 5 minutes for rebuttal, please.
That's fine.
Your Honors, before I begin, first there are 5 assignments of errors. I'm not going to touch on all of them, nor am I going to even go into depth on each one. I will focus primarily on certain issues of the first 3 assignments of errors. Before I begin that, I would just like to talk a little bit about the factual scenario that was presented by the state here. And this was a daughter, the appellant's daughter was involved in this. I think the state's own evidence, the state's own position at trial was that this was an attempt by Mr. Yuschak to get his daughter into some treatment. He himself had asked someone to alert police to be there that day so that they would be able to intervene in a drug sale that he was aware of and had helped, and had hoped that that arrest, that intervention, would get her into the treatment that she needed. So I think it's important as we look at this to remember that. But the reason the police were there so quickly is because that was the appellant's design. That was what he had wanted, was for their intervention to help him get the daughter the help he needed from the heroin epidemic that we see devastating so many of our counties here in Ohio. I would like to begin with first our assignment of error number 1, and that has to do with the issue of the peremptory challenge made by Mr. Yuschak's attorney. What I'd like to focus on with that is kind of what I see as the double standard that the state is pursuing here, and that is it seeks to avail itself of the protections of a Batson challenge, but then seeks to avoid the strong discretion that trial courts and appellate courts give prosecutors in their own Batson challenges. And that is Mr. Yuschak's attorney provided a race-neutral reason for the excusing of that juror when asked. The state spent some time arguing that he came up with some later reasons when pressed further, but what he said after was, again, her concerns about time. So he was consistent, Mr. Yuschak's attorney, on to why he was asking to excuse this juror, and that is that she was nervous about being there, she was nervous about getting out in time, and that was what had caused him to make a peremptory challenge. Now, the trial court's analysis of that seemed to be more of a challenge for cause, is how the trial court was reviewing it. The trial court, instead of discussing whether that was a race-neutral reason for the challenge, the trial court instead stated that, well, I'm not concerned about her concern about time, because she doesn't have any control over that. And I'll try to get her out of here at a decent time. So I'm going to deny your peremptory for cause. Now that would be an analysis where there would be no error if this was an attempt by Mr. Yuschak to excuse her for cause because of her concern of time. But the trial court here did not look at whether or not that was a facially valid reason for excusing the juror, but instead basically said it could accommodate the juror's concern. It didn't even really address.
Didn't the state, maybe I'm mistaken, but I thought that in the interim, the state had pointed out that there were other potential jurors who had also expressed concerns about time, and they were not challenged.
I think that those are distinguishable. The other jurors that had expressed concern about time, I don't know that I would qualify that as concern. They had asked questions about time. This individual juror had specifically indicated she was nervous. she would have she was nervous about it. It would be distracting to her. And I draw that, the distracting from the fact that she indicated she would be nervous. And that is something different, I believe, than the other jurors had indicated. So I believe that that is a distinguishable issue for the other jurors. And again, the trial court's analysis did not, what the trial court specifically said is, well, she only needs to be out by 5, which is something not within her control. So we will not keep her past that, so she won't have to worry. Again, it wasn't addressing the facially neutral peremptory by the defendant. Instead, it was basically addressing the validity of the juror's own indication that she would be nervous. And so I think that beyond some of the legal arguments that, that we've made regarding the Batson challenge, I think that this is very fact-specific, and that the same deference that is afforded the state when making a peremptory challenge is as important, if not more important, when looking at a defendant's constitutional rights to a fair trial and to a jury of its choosing. I'd like to move to our second assignment of error, and that would be the admission of State's Exhibit 23. And there, I would just like to touch briefly on, at first I'd like to talk about the manner in which the exhibit was identified. And I really think that given that the only identification was the girlfriend, they didn't bring in, the state did not bring in somebody who runs the system at the jail. The judges will recall this was an exhibit of some jail calls with appellant and his ex-girlfriend. They didn't bring in somebody who could authenticate the call as being from the system. They didn't bring in somebody who actually even made the recording, gathered it, and put it on the disc. The only foundation, the only identification for this recording was the testimony of the ex-girlfriend. And the manner in which it was introduced through only that testimony, I believe, was improper and an error. Initially, it was identified by handing it to the girlfriend before she had said anything about the voices, before she had indicated that she'd even made these calls that they were going to be questioning her about. She's handed a CD with her name on it, appellant's name on it, and what she guesses or believes is her own home phone number. So that's the first time she sees this. It is marked for her as what the state wants her to testify to. That's the first time she gets the CD. And then the next exchange with the state is, well, the state said initially, there's some writing on it. It says Crystal, it says Yuschak, and there's a number on there. And that's when she says, I think it was our house phone number. And then the call is played for her, and the state said to her, I'd like you to listen, and at that point, your voice is heard. Or, I shouldn't say that. At that point, voices are heard. I'm going to ask you who those voices are. So at that point where she's asked to give an impartial identification of these voices, she's not only received the exhibit with the information, her name, appellant's name, and a phone number on it, she's been told by the state that this is her voice on the recording. Now this in conjunction with the fact that there is no traditional proper foundation for the recording. Nobody from the jail to talk about how it was made. Nobody from the jail to talk about that it was gathered. And no question ever put to the ex-girlfriend if it was a true and accurate recording of the conversation. So I think that those things, together with the failure to properly lay the foundation for the exhibit, makes the admission of that an error. And the state argued that there was no prejudice in this because there were other indications of some racial animus that they believed somehow they tried to use that as motive for appellant. But the only other evidence that Mr. Yuschak had used a derogatory term was at his arrest, where he used that term to everybody around him, regardless of their race. So I think that these phone calls are much more damaging, and I don't think that it's a harmless error to admit it, because the other time he was there was testimony that he used this term, he used it to people of all races and colors. So I do believe that this is different, and I do believe that the error is not harmless. And then finally, I just would like to touch on the issue of the substantial fine that was imposed on the appellant. I'm here as appointed counsel. That means trial court believed Mr. Yuschak to be indigent and deserving of appointed counsel, yet still imposed a $15,000 fine upon him. And I believe that inconsistency, as well as no analysis of Mr. Yuschak's present and future ability to pay.
Counsel, let me interrupt you. Did you say you wanted 5 minutes?
I did.
Okay, you're right at that.
Okay, I'll just finish up real quick.
Okay, that's fine.
That there was no analysis of his present and future ability to pay. At the time he was convicted, he'd been in jail for over a year. The judge sent him to jail for another over 8 years. And so there was no, and the court did not do any analysis of whether there was any future or present ability to pay. And again, in fact, found Mr. Yuschak to be indigent, as evidenced by the fact that I have the pleasure of representing him on this appeal. I'd like to save the rest of my time for rebuttal.
Thank you.
Thank you, Your Honors. May it please the court. Matt Rizzavi on behalf of the state of Ohio, the appellant in this case. Your Honor, appellee in this case. Your Honors, I want to focus on all the issues, but first, if I could respond to some of the issues that Ms. Whitaker brought up in the first 3 assignments of error. And in doing so, of course, we urge this court to affirm the conviction of Mr. Yuschak. The first one is the issue of the Batson challenge. And I would like to note that the appellant in this case kind of ignores the main crux of their argument. Their argument at first is Batson does not apply to anybody but a criminal defendant who is challenging a state's peremptory challenge. That's the crux of their argument. And as you can see, that is not the case. And a well-settled law, and I know this wasn't mentioned by counsel, but well-settled law is clear. When you look into the assignment of Error 1, you look at the 2 cases that the state cited, specifically with McCollum, and I think there was a Supreme Court of Ohio case as well. Your Honor, it's clear that Batson challenges have been expanded not only for peremptory challenges made by the defendant in this case, but also into civil cases. And there's good reason for it. We know also from the case law that we've cited in our brief, this right is not just with the litigants. The right to be on a jury is with the jurors themselves. And I think that's the Powers case, that I think it's a 1991 case that found that and set that out. So in that context, Your Honor, we have to look, Your Honors, we have to look at this issue. And what we have in this case is the only person, the only African-American person on this veneer was excused. Now, their position is they brought up a race-neutral reason. From the state's position, there was no such reason. For instance, if someone says, I have a race-neutral reason, and it's because the defendant is...
Apologize, Mr. Yuschak's family was in the hallway. We got started something there. I apologize.
Your Honors, our position is that race-neutral reason doesn't exist. For instance, if you came up and they said, hey, what's a race-neutral reason? And they said, well, that juror said he didn't like me. And say, no, that juror didn't say that. That wasn't that juror. You got the wrong one. This actually didn't exist when you look at it, because what did this juror say? She said, if it gets to 5:30, I'm going to get a little nervous because I have to be out by 5:30. That was really what came out. We listed in the transcript 4 or 5 other jurors, maybe 6 other jurors that had the same concern. This was just brought up in the ordinary course of voir dire. Hey, was there a time period? Is there a day that you can't go past? They mentioned it. That was clearly already covered by the judge in this case. It's, I think, the transcript on page 35. She made it clear, we're not going past 5. So when this peremptory challenge was made, the court had already known that this race-neutral reason, frankly, didn't exist. Now let's put it in the context of what kind of case we had. It's interesting that the appellant has started their argument to talk about that this was just someone trying to save their daughter from like a heroin dealer, a drug dealer, or from a heroin problem. That's exactly the context that this case was tried in, and frankly, there's a right for people of all races to be on this jury, and this is the case where, frankly, there was an appeal to nullification. And I suggest, frankly, that's kind of what this is about when we say, hey, this is just a person trying to save his daughter. Under this fact scenario where the daughter is being brought to a location to sell drugs with an African-American person who they're accusing of being a drug dealer, who frankly was selling drugs. Under that context, certainly, it's crucial and important that people not be excluded on the basis of race. And there was no race-neutral reason. I'd also note, to deprive the state of Ohio to protect this right, this important right, of not only of the parties, but of the jurors themselves, as we discussed, would fall really in the face of what is the Code of Professional Conduct for lawyers. Rule 3.8 designates a special responsibility for prosecutors to protect justice. And if you look in the comments of that rule, it says prosecutors are to be ministers of justice. So for a prosecutor to ignore the situation, which was so plain, there was not a race-neutral reason, and the only African person on the veneer was going to be excluded in this case, where the defendant was essentially saying, I'm protecting my daughter from this black drug dealer that came into Medina with her, frankly, would be a disservice and would violate Batson. So under the...
As I understand, counsel, the rest of the evidence that was presented, in light of what you're arguing now, there was another person who, Mr. Yuschak?
I think you pronounce it Yuschak.
Yuschak, had anticipated being with his daughter. And that's the person that he had threatened to shoot. And I will say that, you know, in reading these briefs, it wasn't entirely clear what the race of anybody was until, I guess, maybe we got to your brief, and it was clear that at least the person who was shot was African American.
Yeah, I think that would have come out, I think that did come out in the transcript at some point, and obviously the jurors would have known the race of the individuals.
But my point is that, you know, on appeal, it's very important to make that point to those of us who were not in the courtroom.
Thank you, Your Honor. And if I can, I'm going to mention also that issue of the other person, because that goes very much, it's very important towards the issue of purpose, but I appreciate that, Your Honor. Without using too much of my time on this Batson issue, the state believes that we had a right to challenge the peremptory based on Batson. And this is a clear case that not only did the court find that this race-neutral reason did not overcome the situation, but it actually didn't even exist under those circumstances. So we'd ask the court to deny that particular challenge, or that particular assignment of error. We come to the next assignment of error, Your Honor, which appellant discussed. It's the ID of the call, of the phone call. The interesting thing is, the cases that they cite say really what you should be doing to authenticate or lay a foundation for these calls is have the people that are involved in the phone calls testify to them. The state has only one option in this case, obviously. The state's not going to call the defendant. That's the two people that are alleged to be part of this phone call. It's the defendant or his girlfriend. And Ms. Sigler testified, and she testified that it was her voice. And there really was no objection to the foundational issue of these calls. Maybe they objected to the substance of them coming in. There was some objections, but not to foundation. That's why we asked the court to consider this. I think we said under the plain error only. I know now they say, hey, the question was too suggestive or too leading. As the court knows, there's no blanket rule against leading questions. And in fact, if you look at the rules, there's a favoring of leading questions when you come to foundational issues. There was really no question in the court that these two people were the subject of the phone calls, and that wasn't the subject of any objection. And that's exactly the case they cite, and I don't have them, I can get them for you, Your Honor, that I think it was the particular case that they cite is actually completely distinguished. And when you look at the Tyler case in finding that there wasn't proper foundation suggests this is exactly how you do it. You have one of the people that are part of the phone call attest to it. The part that's complained about is the prosecutor showing it. This is a police disc that has information written on it. And the state of Ohio was having a witness identify the item and talk about it. But I think it's pretty clear from the record, there was never any question that she was identifying the boy. She was discussing the subject matter of their call. She was very clear this is the first time she spoke to him immediately after the event. And she had a recollection, independent in her testimony, of the subject matter of their call. The next assignment of error that the appellant focused on was the substantial fine, as she described it in this case. As we pointed out in our brief, Your Honor, the court very clearly was referring to the pre-sentence investigation. And Mr. Yuschak, as the court went over, in an effort to lessen his sentence, in the effort to convince the court to give him a lesser sentence, said, hey, I've got all these means, I've got all these resources, I have all this property, I have a business, I have money, I have a house, and so please give me a lesser sentence. The court, obviously taking note of that, said, well, this is a person with resources. Now, if they want to challenge that now, the court's been very clear in its prior case. The appellant in this situation has the burden of making the record complete with the PSI. The court can only assume the regularity of the court here and the court's decision on the issue of the fine. And it was very clear the court, frankly, was disturbed to learn that while claiming indigence for the purpose of the appeal, and I understand the court the state understands that the situation that trial courts, and they want to make sure someone has an opportunity, it's such a serious case to have the opportunity for this appeal here. So they want to appoint them a lawyer, not leave them without a lawyer. But that court clearly saw, and these are two separate issues here, clearly saw that he was not indigent, based upon his own words that were in the PSI, that he had all these resources.
But the court, at the same time, said, I find you indigent. I mean, how do you square that?
Well, I certainly can't speak for the judge herself, but it is not uncommon when those issues, when the person then subsequently claims, hey, I don't have any income here, I have some resources, but I don't have any income, the court wants to make sure the person has an opportunity to file a notice of appeal. Because what comes next if you don't file, give them a lawyer, and they don't have an opportunity to file their appeal, then the person's going to claim error or have a delayed appeal or not have the opportunity to appeal the case. And I think it's pretty clear that the court, I know it seems to, like inconsistent verdicts, like we have in some cases, on its face they seem inconsistent, but it's very clear the court had a basis for, it was the defendant himself, when he told the pre-sentence writer that he had significant resources. And the court, frankly, it seems from the record, was a little bit offended by that under the circumstances. And I certainly can't speak to why the court then also appointed a lawyer, but I think, I suspect, and I asked the court to consider that the court has a great interest in protecting the defendant's rights to have a direct appeal in this case. Your Honor, if I can move on to, if it's okay with the court, to 4 and 5, manifest weight of the evidence. Your Honor, it's clear that the jury did not lose its way in this case. There really is ample evidence. I know that there's some questioning of the way that the appellant construes the identification. The state disagrees with that. It's very clear from the eyewitness person that she was driving down State Route 18. She saw a man with a hat get out of the driver's seat of the car, come over and lunge and shoot this person. The defendant himself, they call into question his identification in the hospital. They said 60% this is while he was anesthetized. But he identified him in court. He pointed him out. He, as he was shot, Taryn, who was in the car, said, that's my dad. He came out of the driver's seat. We know he was in the driver's seat by the testimony. There's an effort, I would suggest, to kind of conflate the two issues because the eyewitness was very clear during her testimony. After she saw the man in the hat, who's Mr. Yuschak, shoot the victim in this case, she pulled into the next lot, went to the back, and as she gets on with 911, the next person she sees, she says, oh, I see him running. And this is the person now with the boots and now with the hat. She then later realizes, and she's very clear during her testimony, that was a different person. It was a younger man, a thinner man without a hat. And that was, in fact, the co-defendant, Mason Braun, who was disposing of the gun at the behest of Mr. Yuschak. So that's what happened in this case. Now, we have much more than that. We have the defendant identifying him. We have the gunshot residue on his hands. And this is where his important statements that he made on these phone calls and to others is important, and to the police. It's very clear from the phone calls what his purpose is. He said, and also from Ms. Sigler's testimony about what he said when he was calling. This was not, and I know they say this, the state's position that Terry Yuschak was just trying to help his daughter. That's not the way the state argued this case. I know there was some witnesses that said, hey, that's how it first started out. He wanted to go find his daughter because she was abusing heroin. But when he found out that the daughter was going to be coming with someone, now he thought this was this relative of his girlfriend, this Jay, I think it was his first name. He became irate. He said he was going to kill him. He took a gun with him that day, his gun, the girlfriend identified it, and he said he was going to kill him. So now we know that he has anger towards the person that's going to bring her. So that clearly is important towards his purpose. Now I think his statements after the fact are very relevant to someone's purpose. The first thing, one of the first things he says in the call is, I hope that, and he uses a racial slur, that N dies. Very important towards his purpose. If someone would have accidentally or as a matter of self-defense shot someone, it's the last thing they would want the person to do is die. If not for just compassion, but for their own potential culpability. Your Honor, those statements are very clear. And you also look at all the different stories that Mr. Yuschak told to the police. When they first came to him, he said, and I apologize that I don't know the order. At one point he said, later when being interviewed, that this defendant shot at him. Originally when the police stopped him, he said, some other person came here and shot at him and fled down the freeway, he's over there. There was, I think, around about 5 different stories that he told the police. So those are all important and relevant when you're considering the manifest way of the evidence. He had gunshot residue on his hands. There's IDs from both the eyewitness and the victim himself, and of course he is the motive, as demonstrated by his contact with people shortly before that he was going to kill the person that brought Karen. Ultimately, it turned out to be the victim in this case, who suffered grievous injuries in this case. I know it's not particularly the issue in some of these assignments there, but the victim was, it's important when you look at purpose and deciding, not everybody that fires a gun in someone's direction is trying to murder them. In this case, the defendant went at point blank range after he had said he wants to kill the person that's bringing his daughter, fired at point blank range into the abdomen of that person with a .357 caliber revolver and did unbelievable damage.
I think, Counsel, you're out of time. Sorry.
Thank you. First, I would just, I think the court is aware that the decision not to address certain arguments in oral argument is in no way a waiver of those arguments. It's just a decision to focus on certain issues that I wanted to highlight for the court. I'd like to respond to the state's assertion that defendant was asking for juror nullification at trial and is again asking for the same here by discussing some of the facts and circumstances as the appellant. That's absolutely inaccurate. This court, in most of its assignments of error, must consider whether the error was harmless, and issues of facts, circumstances, the other evidence presented to the jury are absolutely relevant to that. So the fact that Mr. Yuschak wanted the police to be there, the fact that Mr. Yuschak wanted the police to be there for a reason, which was to get his daughter into drug treatment, certainly goes to the issue of purpose and Mr. Yuschak's conduct that day. As the court indicated in questioning the state, the statement that I'm going to kill that guy wasn't even directed at the person that his daughter showed up with that day. So those factual issues are very much before this court in almost all of its assignments of errors, as it addresses whether or not the error was harmless or not. And this is also especially true given that we have argued that the evidence was not overwhelming against appellant. The statement of the female, while the recitation by the state makes it sound very consistent, I think we've gone into detail in our brief how inconsistent her statement was initially and how she didn't indicate certain things and mixed up different people. This is especially relevant given that when Mr. Hope, the victim, was approached in the hospital, he testified that he could only be 60% certain that the person that shot him was even one or two of the 2 photos that were familiar to him. So it's in these facts and circumstances that the court is addressing these issues. So I do believe that that is all very relevant to this court and very relevant to its consideration. I did want to also address the state continues to rely on that recording and where he says that he hopes the racially derogatory term dies. Well, it may not be how we wish he felt about the situation. This was a man that was transporting his daughter all over Northeast Ohio to provide her with heroin that he believed was killing her. It is certainly not what we would want from people and how they feel, but it's certainly not the first parent that wishes ill will to somebody who's selling his child drugs. But that is not what he went there for that day. Again, his purpose, which was an element of these charges, and what the court must consider when it addresses the issue of harmless error, was to get her help, was to have the police be there. And this was a different person than he even expected to be there with his daughter. It was a family member of his girlfriend that he expected to be bringing her. And finally, just briefly, I'll touch on the issue of the fine. It's the state that is relying on the PSI when it talks about that the PSI indicated that he had all these assets and things. And if the state wanted this court to consider that, it should have supplemented the record. What we're relying upon and what I believe the questioning from the bench has identified is the inherent problem with the fact that there was a finding that Mr. Yuschak was indigent. Now, it may be that the court was concerned about protecting his rights to appeal, but the court made a legal finding that Mr. Yuschak was indigent. And that finding is the regularity that this court needs to rely upon, that was a correct finding, that he is indigent, and therefore the decision to impose the fine wasn't proper. Thank you.
Thank you. The court will take the matter under advisement. A written opinion will be prepared and sent to both sides, as well as we release our opinions electronically on our website as well as the Supreme Court website. Thank you again for your presentation.